In 1988, a small law firm in Wilmington changed a single statute and accidentally created the world's largest legal loophole. The conventional story is simple. Delaware became a corporate haven because it has friendly tax laws and a specialized court system. That's the accepted explanation. It's also incomplete. What actually happened involves a specific trust structure, a deliberate legislative choice, and a cascade of unintended consequences that now obscure trillions of dollars. The real story doesn't start with tax cuts. It starts with privacy. For most of American history, trusts were transparent. If you set up a trust in New York or California, creditors could see who benefited, who controlled it, and what assets it held. The trustee's name was public. The beneficiary's name was public. This made sense. It prevented fraud. But in the 1980s, that began to change. And the catalyst wasn't greed. It was a court case. A man named John Doe, not his real name, had money, legitimate money, but he had creditors too, and those creditors were coming. The problem, under standard trust law, his creditors could reach the trust assets because the trust was visible, and John Doe's interest in it was documented. So his attorneys asked a question. What if a trust could be structured so that creditors couldn't trace the beneficiary? What if the law itself made that possible? Delaware's legislature was paying attention. The state had already built a reputation as a corporate charter hub, easy incorporation, low fees, a specialized chancery court. But corporations weren't the only clients. Wealthy individuals were looking for somewhere to park assets away from prying eyes. In 1988, Delaware passed a law, the Qualified Dispositions in Trust Act. It was quiet. Almost no one noticed. What the law did was radical. It allowed trusts to be created where the beneficiary's identity didn't have to be disclosed to the trustee. More precisely, it allowed someone to set up a trust, fund it with their own assets, and then, through a legal mechanism called a duress clause, argue that they shouldn't have to reveal who benefits because they were forced into it. On its face, absurd. In practice, genius. Because the law also said, if you can't prove the beneficiary exists, creditors can't reach the trust. Word spread quietly through wealth management circles. By the mid-1990s, other states were watching. Nevada passed a similar law. South Dakota followed, but Delaware remained the standard. Why? Because Delaware also had something else, the Chancery Court, a specialized court system where business disputes get resolved by judges who understand complex financial structures. No juries, no surprises, just consistent precedent. The system worked like this. A wealthy individual, let's say a real estate developer, would create a Delaware trust. They'd transfer assets into it. Then they'd claim they'd been coerced into the arrangement. The trustee would say, I don't know who the beneficiary is. The creditor would say, tell us. And the court would say they can't. The law protects that information. The assets disappeared from public view, legally. Now here's where the system began to compound. As more wealth flowed into Delaware trusts, more trust companies opened in Wilmington. More law firms specialized in trust creation. More accountants learned the mechanics. It became an industry, a self-reinforcing loop. The more trusts existed, the more expertise was available. The more expertise, the more attractive Delaware became. The more attractive it became, the more trusts were created. By the early 2000s, Delaware was managing somewhere around $200 billion in trust assets. By 2010, over $500 billion. Today, estimates suggest the number is in the trillions. Not all of this is illicit. Some is legitimate estate planning. Some is asset protection from lawsuits. But the structure itself, the opacity, was the point. It was designed to obscure, and it did. The real explanation, then, isn't that Delaware was greedy or corrupt. It's that Delaware solved a specific legal problem, creditor access, and then created a feedback loop. Once the infrastructure existed, once the expertise was there, once the courts had precedent, the system perpetuated itself. It became the default, not because it was the best solution, but because it was the first mover and switching costs were high. This matters because it shows how financial systems don't collapse from sudden evil. They evolve from small decisions, made in response to real problems, that create unintended consequences. A trust law designed to protect debtors from creditors became a tool for hiding wealth. A court system built for expertise became a mechanism for opacity. The system worked exactly as designed. That was the problem. Today, Delaware trusts hold assets belonging to everyone from international oligarchs to American entrepreneurs to inheritance beneficiaries. Some of that wealth is legitimate. Some is hidden from tax authorities. Some is proceeds from crime. The system doesn't distinguish. That's by design. The law doesn't ask where the money comes from. It only asks whether the paperwork is correct. And here's the final loop. Because Delaware trusts are so effective at hiding wealth, other states have had to compete by creating similar structures. Because other states created similar structures, there's now a network of jurisdictions with comparable opacity. Because that network exists, the system is now self-reinforcing across state lines. It's not a conspiracy. It's a system responding to incentives. The predictable outcome, trillions in assets now exist in a legal gray zone. They're not illegal to hold. The trusts are properly formed. The taxes, depending on structure, may be paid, but the beneficiaries, the sources, the ultimate purposes, those remain invisible. This wasn't inevitable. It was a choice, a series of choices, each one rational, each one creating feedback loops. Understanding this matters because it reveals how large financial structures persist. They're not maintained by constant active conspiracy. They're maintained by rules, incentives, and the network effects of those rules. Once a system is established, it becomes the path of least resistance. Changing it requires either a major external shock or a deliberate decision to rebuild the rules entirely. So when you see Delaware mentioned in investigations into hidden wealth, and you will remember, it's not the exception. It's the system working as designed. A system that began with a legitimate question, how do we protect debtors, and evolved into something else entirely, not through malice, but through the predictable mechanics of incentive structures and network effects. The lesson isn't unique to Delaware. It applies to every financial system, every legal structure, every rule set that creates incentives. Small choices made with good intentions compound into large systems. Once they're established, they become invisible. We stop questioning them. They become how things are done. And by then, changing them requires more effort than accepting them. This is how the world actually works. Not through grand conspiracies, but through feedback loops. Not through sudden collapses, but through predictable evolution. And the people who understand these systems first, the ones who see how incentives compound, are the ones who can navigate them or eventually change them. That's what we explore here. The systems beneath the headlines, the mechanics that were always predictable once you knew where to look. Subscribe to this channel, because the next financial structure we dismantle might be the one affecting your own world. This video is for educational and informational purposes only and is not financial advice. Always do your own research. Subscribe to this channel so you don't miss the next system we dismantle. This video is for educational and informational purposes only and is not financial advice. Always do your own research.